couple ways, mistakes that people make. The attorney often botches it. When you do the beneficiary of an IRA, particularly if the beneficiary is young, like a child or a grandchild, you need very specific language in order to qualify as a designated beneficiary, and the estate attorney better know that language. There was just an article in the Wall Street Journal that said, oh, it's really complicated to do that language, so don't name young beneficiaries. And I was, no, you got it all wrong. Just go to somebody competent who knows the language and get it done right. And interestingly enough, I had Bruce Steiner, who's also an IRA expert, estate attorney, on the radio, and I mentioned that, and he said, I know, I read that, I went nuts. And interestingly enough, both he and I wrote letters to the Wall Street Journal saying you should do a retraction or do something. I even gave them suggested language, which they did not choose to print. But it's really important that the language for the IRA, you have to get it set up right while you and your wife are alive. All right? The other thing is it has to be administered properly after you die. And it's probably botched just as often, if not more, after you die. You have to have, I'll just give you one example. Titling. Oh wait, all right, I'll go a little bit out of order. If you don't put the right title on, remember for Ed I said inherited IRA of Ed for the benefit of Ed III? Let's say instead the financial advisor doesn't really know that stuff and he just uses Ed III. By the way, true story. Dad, son, both have the same financial advisor. Dad dies with $1 million in his IRA, leaves it to son. Advisor puts it in the name of the son. That's a violation. You're not allowed to put it in the name of the son. It has to be inherited IRA of Ed for the benefit of Ed Jr. But this financial advisor didn't do that. Ed Jr. had to pay tax on $1 million. That is misery.